Good afternoon. The Senate Judiciary and Public Safety Committee will come to order. Today is Monday, March 17, 2025, and we do have a quorum present. Members, we have a full agenda today, so let's jump right in. We're going to start with Senate File 447, Senator Rest, Consumer Protection, Restitution, Account Establishment. Members, we're going to focus our committee time on sections 1 and 2, which are the provisions within this committee's jurisdiction. It's anticipated that we will send this out from here to Finance, I understand. We are going to have an amendment from Senator Rust with which is a tax jurisdiction amendment. I'm sure the chair of that committee would be okay with us addressing that amendment today.
Thank you.
Senator Rust.
Thank you, Mr. Chairman. Senate File 447 creates a state-level consumer fraud restitution fund to help scam and fraud victims recover financially. That is the purpose. The language of the bill is directed toward that. Currently, the Attorney General collects civil penalty payments from consumer fraud enforcement cases. When there are victims associated with such a case, they receive that restitution directly, but in most cases there are not, and so those dollars are sent to the general fund. The bill proposes to set up a new fund and directing money there, capped at $1 million a year. It could be as little as no dollars a year, but capped at $1 million a year, and then distributed as called for in the bill. The amendment addresses, which is the A7 amendment, members. First of all, in the first section, is a very highly technical amendment that just makes sure that the definitions that are used here refer to sections later in the bill so that there's no confusion about them. And then on page 8 and line 27 and page 10, line 15 are tax year dates that make the bill correct with regard to the taxability of the any payments that are made from the fund. And Mr. Chairman, I have members here from the AARP who call themselves the fraud fighters, and so they are my witnesses, and you'll be hearing from them today. And I also appreciate Senators Carlson, Curran, Klein, and Dornick as co-authors on the bill.
Senator Rust and members, because this bill has been heard substantively in another committee, it's come to us from state and local government and from Commerce. We're not going to take a lot of testimony here today. We appreciate all the support from AARP members that have come here in support of the bill, but we're going to hear from Professor Cox, and then we're going to hear from one representative from AARP, Helene Johnson, for just a minute or two.
Thank you, Mr. Chairman. Appreciate that.
Focus our attention on sections 1 and 2 of the bill. Before I ask council just to give us a brief description of why those provisions are within our jurisdiction, we're going to ask Senator Carlson, the co-author in the bill, to move the A7 amendment that Senator Rust has already described. Any questions or discussion about the A7 amendment that members have in front of them? Not seeing any. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Ms. Primo, could you tell us what about sections 1 and 2 brings this bill within our jurisdiction?
Mr. Chair and members, Sections 1 and 2 determine the way that funds collected by the Attorney General are distributed, funds collected through the litigation process. Therefore, they're within our jurisdiction.
Thank you. Professor Cox. Go ahead and identify yourself for our record and tell us what you'd like us to know.
Thank you, Mr. Chair, Senator Rest. My name is Prentice Cox. I'm a professor of law at the University of Minnesota, former assistant attorney general for many years, and a consultant to AARP on consumer issues. I'm just going to briefly describe how the proposed restitution fund would work. Money recovered by the Attorney General in consumer enforcement, public enforcement actions are really of two types. One is restitution that goes back to the consumers harmed by that defendant, where the restitution is paid for by the defendant. Nothing in this bill changes that type of recovery. All other monies recovered by the Attorney General, including civil penalties, attorney's fees, general payments to the state, and money that was recovered as restitution but was unable to be distributed for whatever reason, all currently go to the general fund under Section 16A.151. What this bill would do would place 50% of that money, up to $1 million a year, into the restitution fund, which leads us to the second part, how money would go out of the fund. Money can only go out of the fund to pay for restitution to consumers and Attorney General consumer enforcement actions where the court orders restitution. But where the defendant is insolvent or for any other reason, the AG can't recover the restitution money from defendants for those consumers. This means restitution paid to Minnesota consumers who are owed money from the consumer enforcement action but will never recover that money without the existence of this fund. There's no new authority for the Attorney General to bring a consumer protection action here, simply to access the fund to pay restitution to consumers who were defrauded and would otherwise have no recovery. Finally, I'll note that subdivision 8 of Section 2 of the proposed new Section 8.37 would require the AG to submit an annual report that identifies all the cases resulting in money into or out of the fund.
Thank you, Mr. Cox. Professor Cox. Any other questions? Any questions for Professor Cox while he's at the testifier table? I would just note, Professor Cox, that subdivision 10 provides that there is no private right of action with respect to payment from the account or administration of the account. So, is that correct?
That's correct, Mr. Chair.
Thank you, Professor.
Thank you.
All right, Helene Johnson, come on forward, please. Ms. Johnson, welcome to the committee.
Thank you.
Please go ahead and state your name for the record, and take a minute or two to tell us what you'd like us to know.
Okay. My name is Helene Johnson. I'm a resident of Golden Valley. Excuse me. And I'm here to talk about.
I'm sorry, can you pull the microphone down towards you as well?
Good idea.
Thank you.
Does that help?
Yes.
And straighten it out? Okay.
you.
Obviously, this is not something I do every day. Okay. I'm here to tell about my experience as a victim of fraud. I am someone who dealt with the dental problem of Dr. Kemmel and the Woodbury Dental Arts fiasco, which is a real scandal. And I was somebody who lost my front teeth, but they broke. I was in the market for implants, but I only needed them on top. So after looking at a number of options, I wound up going all the way to Woodbury because they were willing to customize and just do implants on top. So that's how I got there. And they also told me that I had to pay for implants up front, and that is not covered by insurance at this point. So that was $15,000. It took me a while to get that money from family and friends because I hadn't expected that. And then I proceeded, and I wound up finding out that halfway through my procedure that he was bankrupt and the whole thing just was closed. Everybody was out of luck. And that really is a problem because you have people who have just gotten their teeth pulled and so forth, and they didn't even have a chance to go in and get the rest of the situation. So the main thing that was a problem was that there was no way to get any money out of Dr. Kamel. He told no one he had, that his license had been suspended, and then it was revoked, and that's why he closed the clinic right away. And he knew this for quite a while, and no one was informed. But by that time, there were so many outstanding debts that needed to be paid, and a lot of patients that would not get paid at all. So I'm really here to represent those in the future who might find themselves in similar situations. It's not fun not being able to eat anything more than soup and mashed potatoes, I can tell you that, especially when my son's wedding and my 55th Carleton College reunion happened during the time period when I didn't have any permanent implants. So I appreciate your time. I know time is short, but there are people like me that are actually victims and had nothing to do with it. We had no knowledge of it.
Thank you, Ms. Johnson. Appreciate you coming here today and sharing your story with us. Any questions from members of the committee for Ms. Johnson? Thank you very much. Any questions from members of the committee for Senator Rust, our chief author here? Discussion from members of the committee. Senator Anderson.
I don't know if this is for Senator Rust or not, Mr. Chair, but I have a question where it says on 1.14, then the court, then we have deleted language, or Attorney General must deposit the money in the Consumer Protection Restitution account. And I'm just wondering why we don't include the court then on other lines where the Attorney General has been mentioned regarding the creation of the account and other things that are done. Why we don't put the court or Attorney General. There's many lines in Section 2 that should include, I think, the court along with the Attorney General rather than leaving the court out of the issue or the situation. Maybe there's somebody that can explain why we don't include the court in other lines where the Attorney General is mentioned.
Mr. Chairman,
Senator Rust.
I actually think that is being included, but if you would call back to Professor, I think he can identify the lines and the rationale.
Professor Cox.
Thank you, Mr. Chair. Senator Anderson, the court acts here in this context to order the payment of restitution or to order the payment of the defendant, money by the defendant. In other places in the bill, the action is by the Attorney General under the authority of the order provided by the court. So an example of that would be, there's lots of, like you said, there's lots of references to the Attorney General here. The order by the court is for restitution, let's say, to the Woodbury dental situation, to the victims of that fraud by that dentist, that certain people be awarded the amount of their loss as a result of that fraud. The Attorney General then would have the authority to identify precisely those people and that amount of money, and then if, in this case, you probably wouldn't have it, but if it was a large case with tens of thousands of people, Subdivision 4, for instance, says the Attorney General may pay an account administrator. That's simply the discretionary act of the Attorney General in order to distribute that restitution money that's been awarded by the court. And in all consumer enforcement, public enforcement actions now under existing law, that would be a discretionary act of the Attorney General pursuant to the order of the court. So in the places where it refers to Attorney General, refers to the discretionary acts of the Attorney General that's no different than under existing public enforcement law.
So, Mr. Chair,
Senator Anderson.
Mr. Cox, why wouldn't the court be included in making that decision as to how the account administrator could distribute that? Why couldn't the court do that as well as the Attorney General? Why couldn't that be a court or Attorney General?
The court, Mr. Chair, Senator Anderson, it would be implicit that the court could always revisit its prior orders and therefore change the discretion of the Attorney General under the order. So the court could do that. You wouldn't put the court into the subdivision because that isn't the typical process. The typical process is the court makes the award, orders the payment, and then the Attorney General is given discretion to essentially administer that payment, just as an agency is given authority to administer the budgets that are voted by the legislative branch.
Well, Mr. Chair, I really think the word court or Attorney General should be included in all of those areas, but I guess that is up to the committee to decide that, and I think that to me, it gives too much power to the Attorney General to make that decision, and I think the court should be involved in that. Thank you.
Any other discussion from members of the committee? Senator Howe.
Thank you, Mr. Chair. I'll try to make this as quick as I can. Could either staff or the professor or the Senator Rest explain to me, maybe clarify who an eligible consumer is? Because I see it says a person directly impacted. How does that pertain to, who else does that pertain to? Is just that individual, or do their errors or anything else apply to that? Or is it just that consumer?
Professor Cox.
Go ahead.
Thank you. Mr. Chair, Senator Howe, it would be, the eligible consumer would be someone who would be the recipient or the putative recipient of restitution under a court order. So maybe I'm not answering your question.
Mr. Chair.
Senator Howe.
So it dies with the individual. If the individual passes, the claim dies with the consumer.
Well,
Professor Cox.
Mr. Chair, Senator Howe, all right, now you're testing my knowledge of the rules regarding here there's some, I don't know the answer to that question without doing further research, you know.
So whatever the existing law is with regard to the continuation
Continue
of
to be
valid
followed.
claim.
It's not special law here.
Yes.
Yeah.
Thank you, Mr. Chair. That would be right. Yeah.
Senator Howe.
I don't know what that is, but I'll go with that, Mr. Chair. Thank you. Then my next
I don't know what it
concern
is
is the impractical payments. So to me, I'm a little concerned that the Attorney General gets to decide what's unreasonable time, whether it's too small of an amount to justify, and whether it's did not redeem a payment within a reasonable time, because all those are left undefined, and that's, I guess, I'll just leave that as a general comment, or if they want to comment on it, that's fine, but that raises a concern for me, that the Attorney General with no definition gets to decide what that is. And, you know, depending upon what Attorney General's in place at the time, it could change over time. But I'll just leave it at that. That's my concern upon reading it.
Any other questions or comments from members of the committee? Senator Carlson.
Thank you, Mr. Chair. And I believe this is a question for Mr. Cox. If there is a court decision on this and an award given, is there any possibility of this becoming any kind of, any level of class action where someone finds that there was an award and then tries to get a claim out of the dispensation?
Professor Cox.
Mr. Chair, Senator Carlson, if there's a private action, there's nothing in this, a separate class action, there's nothing in this bill that would impact that. Public enforcement and individual consumers' right to bring their own claim in the court are separate, and that claim could proceed. Now, if that person wanted to bring a class action about the distribution of money from the restitution fund, that would be prohibited, as the chair pointed out previously, under subdivision 10. We don't want, we don't want to encourage, this is within the public enforcement action. This is just the authority of the Attorney General to have some place to find compensation for people who are victims of fraud where the defendant disappears or is otherwise unavailable, which right now just means that they're out of luck because there was not going to be a private action in that situation. And the public enforcement action isn't able to get them recompense. And so this is an attempt to try to get people like that, like victims of the Woodbury dental scam, compensation where they really have no other realistic alternatives.
Thank you, Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. Under the way the bill's drafted here, is the Attorney General going to be making any discretionary choices on which eligible consumers are going to be awarded something from this fund, the order in which they're awarded, the amount in which they're awarded? Is there any discretion or policy decisions being made by the Attorney General here?
Professor Cox.
Mr. Chair, Senator, no discretionary decisions that are any different than what happens today with any public enforcement,
No special.
consumer enforcement action.
No special discretion, Mr. Chairman.
no-
Senator Kroon, if that's what you're looking for.
Senator Kroon.
Thank you, Mr. Chair, and thank you for that answer. There may not be any special discretion here, but there is the customary discretion that the Attorney General has in these types of enforcement actions. And obviously, my concern rests with the transparency right now in the Attorney General's office and what the public is allowed to see in terms of policy decisions, what the public is not allowed to see, most importantly. And this kind of directly goes, relates to my bill, Senate File 73, and how the Attorney General classifies a lot of this data, particularly on non-individuals. And I notice in the packet, there's a letter from Minnesotans for Open Government, who also have some concerns with how this is going to work from a transparency standpoint with the Attorney General's office. And they say it's unclear what other data might be available through data requests made by the press, citizens, or policymakers who are seeking to evaluate the operation or the administration of the proposed consumer protection restitution account. And I guess my concern here is there's going to be this pot of money that eligible consumers may be entitled to or think they're entitled to. They may try to get some and maybe they won't be able to get it, and they'll maybe try to figure out why they weren't able to get it, and they're going to get stonewalled from the Attorney General. And we're not going to be able to really see the policy decisions or why. I know there's a report that the Attorney General puts out here, but that's pretty conclusory in what's in the report. And what's behind the curtain and how those decisions are being made, it's not clear to me the public's going to have any access to that. So I'm wondering if the Senator Rest or Professor has any comments on that.
Senator Rust.
Mr. Chairman, I think that's a solution in search of a problem. I don't accept the premise that there aren't rules, processes that are covered in this bill that wouldn't be acceptable to any and all victims of consumer fraud. The Attorney General, as the professor indicated to start with, is not given any additional authority. We, in particular, limited the the amount of dollars that would be otherwise available for these individuals, no more than $1 million, and it's limited to half of whatever total funds would be there. I don't share your opinion, the opinion that you're expressing about the Attorney General's and his office and through an administrator of these funds, and the requirement that his office provides an annual report on the distribution of the funds, and that a consumer who was part of that could certainly still ask questions about how it's administered, but not a private cause of action. And that seems to me to be any number of protections for recovering some of the funds that they lost, and almost more importantly, as we've heard in other committees, recovering some of their dignity.
Mr. Chair.
Senator Cronin.
Thank you, Mr. Chair. And the Attorney General may not have special powers here, but the existing system right now isn't working. Of course, the consumer can ask these questions, but that doesn't mean they're going to get an answer, particularly after the court case in 2002, the Energy Policy Advocates decision, which has really created a situation where the Attorney General really doesn't have to disclose any of this information. So all you're going to get is the conclusory information that's set forth in the report, and a consumer who is wondering why they were not given an award under this new account is not going to have any access to their Attorney General's office to figure out why exactly that would happen. And Mr. Chair, I don't know if Minnesotans for Open Government is on the testifier list, but I certainly would like to hear what they have to think about this issue if they're in the audience and could testify to it.
So Senator Cronin, it sounds like the remedy that you have in mind is your own bill, which we heard and laid over for stakeholders to work on to see if there can be some agreement on remedying that. I'm hopeful that you are working on that, and perhaps we'll have it come back to the committee. But as I indicated when we laid that bill over, it's an issue of concern, and we would like to be able to address that if we possibly can. But that's a bigger issue than just this bill in front of us, right? Senator Cronin.
Thank you, Mr. Chair. I appreciate that, and I do believe we have a meeting on the calendar finally, so hopefully we'll be making some progress on Senate File 73. But this bill is in front of us now, and I do have a potential solution here that would not necessarily be Senate File 73 that relates specifically to this bill, and that would be the A6 amendment. So I'd like to offer that, Mr. Chair.
Staff will distribute the A6 amendment. Senator Cronin, did you make Senator Rust aware that the A6 amendment was going to be coming today?
Mr. Chair, I just
Mr. Chairman, that's just fine. I don't care. It's fine. That's what the committee process is about.
I know, it's not required. It's just, sometimes it's just simply a matter of professional courtesy. Thought we'd check and see on that, so we all know. Senator Cronin, we have the amendment being distributed. Why don't you go ahead and describe your amendment?
Thank you, Mr. Chair. It's a pretty simple amendment regarding data classification, and it simply states that communications and non-investigative files regarding administrative or policy matters relating to this specific consumer protection restitution account are public data on individuals and non-individuals. And this would just simply assure that somebody who's been a victim under this statute and would have the tools available to understand how the Attorney General is making decisions on the awards pursuant to this statute. So that's what the amendment gets at, Mr. Chair.
Mr. Chairman,
Senator Rust.
there is a representative from the Attorney General's office here who could respond to what additional action would have to be taken with regard to this, if she may come forward?
If she wishes to, stand up, come on forward. And while this testifier is coming forward, Senator Cruin, did you by any chance notify the Attorney General's office that you were planning to offer an A6 amendment that they would have an interest in?
Mr. Chair, no, I did not.
Okay, go ahead and identify yourself for the record.
Hi, Jessica Whitney, Deputy Attorney General over the Consumer Protection Section with the AG's office.
Go ahead and provide us with your reaction to this A6 amendment that you have just become aware of.
I would need to read the amendment and take it back and discuss with the Attorney General. I will say now, we are often concerned about data provisions, especially concerning private individuals and releasing their information. I will also say that when we do settlements and restitution, the OLA monitors us and does a thorough review going line by line every 2 years or so on how we do restitution. And that restitution, I've served a few attorneys general, is always priority and always trying to get all the money out to the consumers in as much as possible. So, but we need to look at this, and I take it to the AG.
Professor Cox, do you have any response you'd like to supplement that with?
No, Mr. Chair, thank you.
Senator Rust, your thoughts on the proposed A6 amendment?
Mr. Chairman, I share the questions that the Attorney General's representative has brought forth here, and other than that, I don't have the expertise to respond.
Any members of the committee wish to weigh in at this time with regard to the proposed A6 amendment?
Mr. Chair.
Senator Cruin.
Thank you, Mr. Chair. I think it would be fair to have Mr. Ealing come up and testify just to give his perspective on this now that the Attorney General's representative has come up to testify as well.
Senator Cruin, that's fine if Mr. Ealing is here and would like to testify, but you mentioned earlier in your testimony that there was a letter from Minnesotans for Open Government in our packets. We're not aware of any such letter, Senator Cruin. Maybe you received one, but it's not in our committee packets, nor has it been distributed to any members of the committee.
Mr. Chair, my apologies. I got it as I walked in here. I made an assumption that it was in the packet, so my apologies. That's an even better reason why Mr. Ealing maybe should come up and testify.
Yeah, I'm curious. Come on forward, Mr. Ealing. Ms. Whitney or Professor, make room for Mr. Ealing, and maybe we can get an understanding of why this matter is just now coming to this committee's attention on this bill as well. Mr. Ealing.
Thank you, Mr. Chairman. Matt Ealing, Minnesotans for Open Government. The letter that Senator Cruin is referring to was from a previous committee stop that I had shared with him. I wasn't sure that this issue was going to come up today in this setting, so that's why I did not distribute one to the entire committee.
Well,
It's
this
come
is
up.
the Data Practices Committee, Mr. Ealing. You, of all people in this world, should know that.
Yeah. Yes, sir.
And we've got an amendment in front of us now, premised in part, I assume, on that, which was printed on 10/26 this morning. So there's been at least 2 hours before the committee gavelled in where this amendment could have been shared, including with the Attorney General's office, that would be directly subject to this amendment. Again, while it's not against any Senate rules or committee rules to bring amendments like this, we've had this conversation in each of the last 2 years in the difficult position it puts this committee in when we are surprised with amendments that have significant impact, compromises this committee's ability to do good public policy making. Mr. Ealing, what would you like to add at this time?
Mr. Chairman, if there was any miscommunication, it's entirely my fault. I am a volunteer and have been working on a long project for work, so I was not able to circulate anything to the entire committee, my oversight, so I apologize. I'm happy to speak to the issue if the committee finds it helpful.
Please do. Who else
So-
said please do?
Mr. Chairman, members of the committee, Because of the issues that have been raised by Senator Cruin's bill, both here in the Senate and in the House, and it's also a concern of our organization, stemming from the passage of the decision in the Energy Policy Advocates case. And as the legislature starts to take on issues such as are in this bill, and let me be clear that we are neutral on this bill from a policy standpoint, what we're concerned with is, does the Attorney General, as the office that takes on new policies, new authorities that are given to that office by the legislature, does the public have access to information about how the office is handling those new authorities? So in particular, this bill creates the ability for the Attorney General to distribute monies. The way that the Energy Policy Advocates decision changes the Attorney General's data classification is that only at the end of an administrative or policy process do you understand what's happened. In any other state agency, you can make a data request and find out what's happening while the process continues. And so we think it's appropriate to change, at least in regards to this bill, the transparency provisions, the data classification provisions, so the public can find out as the process moves forward what is happening. We'd like to see that changed, as Senator Cruin's bill does or would do for the entire operation of the Attorney General's office. So that's our basic take on this bill, Mr. Chairman, members.
Thank you, Mr. Ealing. Any questions or comments from members of the committee for this testifier? Thank you, sir.
Thank you.
Anyone else want to offer their expertise while you're in the room? Not seeing anyone come forward on that. Members, my own thought is that this is an important amendment to consider, but not only in the context of the proposal for a restitution fund that's before us. It's a bigger question raised by the energy policy decision by the Supreme Court from 2 to 3 years ago, which is was a subject of a committee hearing that we had already, and on which a number of stakeholders are meeting to try to come up with a solution that can be presented in the bigger picture to this committee. And I'm a little bit concerned not only about the late arrival of this proposed amendment without opportunity for the Attorney General's office to review and consider it, let alone our data practices counsel sitting to my right, in terms of ability to share and have a conversation with the committee about the implications here. But it could have an impact on Senate File 730, which I think is the Senate file we're talking about, from Senator Cruin, that seeks to address the same issues in a much broader context. I'm personally not comfortable piecemealing it, and certainly not with only this short an opportunity to consider it. I think it is a very important issue, but I think it ought to be addressed in Senate File 730 if it gets addressed at all. And so my recommendation is going to be to vote against the A6 amendment, not necessarily on the merits, but because I don't think we have enough information right now to consider the merits on it, and I don't think we ought to do it in the context of just the single proposal that's before us, since it has much broader implications than that. Any further comments from Senator Rest as the chief author as to your position on this amendment?
No, sir.
Senator Cruin moves adoption of the A6 amendment. All those in favor say aye. Aye. Opposed?
Nay.
Motion does not prevail. The amendment is not adopted. Any further discussion on Senate File 447? Senator Limmer and then Senator Western.
Thank you, Mr. Chair. Senator Rest, when I think of the word restitution, I'm kind of reminded of recent restorative justice programs. You can't hear me?
No, I can't. The what
I'll try
program?
and talk loud into the microphone.
Thank you.
Senator Rest, when I think of the word restitution, I think of what restorative justice programs are using as well. However, those restitution programs originate between a criminal and the victim. In this case, or in that case, the restitution dollar amount would attempt to get funds or value from the perpetrator to the victim. And that through that, there's a restorative process that can hope to be achieved, and perhaps the perpetrator will begin to realize the damage that was done to the victim. In this case, the monies or the value is transferred from essentially the state at the direction of the Attorney General to the victim. And I haven't heard of this model before. Do you know of other states that are doing this currently?
No, but my testifier
Senator.
does.
Professor Cox.
Mr. Chair, Senator Limmer, the CFPB, the Consumer Financial Protection Bureau, has something called the Civil Penalty Fund, which has been used in a bipartisan way under the Obama and first Trump administration that operates very similarly to this. And the model would be that. There's been a study of that done, published in the Illinois Law Review, that showed it was incredibly efficient and provides money back to people who otherwise would receive no compensation. And I would add, in addition to that, to the extent that a defendant in a consumer protection action is able to pay that money and thus create that restoration and whatever other benefits come from the incentives from being required to do that, they would do that under, if you pass this law or not. This only exists where the defendant becomes insolvent or otherwise the money can't be found and recovered from that defendant. So this is a special situation. And in that situation, private right of action is not going to do any good. It just means people are out of luck. They're not going to get anything. And this is a way to take money paid by other defendants for civil penalties or, generally money to pay to the state, and rather than it going to the Treasury, a portion of that would go toward recompense for people who would have no ability to obtain compensation for their loss otherwise.
Senator Limmer.
Thank you, Mr. Chair. Senator Rest, do you have an idea of how much money would be collected in an account year to year? If
Mr.
this
Chairman,
passes?
Senator Limmer,
Senator
it could be zero or any amount above zero. It
Any
all
amount
depends
of-
on what actions were taken and the cases that were heard by the courts. In a given year, may be unlikely, but it could be none that resulted in funds under the circumstances described in the bill going into the special revenue fund. So that's why it is not a drag on the, otherwise on the general fund. All of nothing is still nothing.
Mr. Chair.
Senator Limmer.
Thank you, Mr. Chair. So anywhere from zero on up.
To
kind of a-
50% with a cap of, Mr. Chairman, with a cap of $1
Senator
million.
A cap of $1 million
Yes,
in
it's in
aggregate?
the bill.
In aggregate.
Senator Rust.
Professor, do you have a different opinion on that?
Mr. Professor Cox.
Thank you, Mr. Chair. Senator Glimmer, $1 million per year limit. So the fund could be more or less than that, but no more than $1 million per year.
Mr. Chair,
Senator Limmer.
I'm kind of curious. I don't know of any accounts that are administered by state officials that don't have an opportunity for the public to understand how those decisions are governed and how the funds may be administered. It's kind of unfortunate that Senator Cruin's amendment didn't pass. The way this bill is written, the public does not have an opportunity to understand how the Attorney General is handing out this money. It's certainly something that I think we should consider further as this bill progresses. I don't know of a single government agency that does not allow the public to understand how administrations work in state government, except for this exception. And so I'm trying to fathom, why would we want to protect the Attorney General's decision-making from at least the public scrutiny? It's a mystery to me.
Mr. Chairman,
Senator Rust.
I would just direct Senator Limmer's attentions to subdivision 4 and 5. I think there, if he reads those carefully, there are answers there to his question.
Senator Rust, what page are you looking at? Is that section 2, subdivisions
Section
4 and
4,
5?
beginning section, subdivision 4, 3.3, is subdivision 4, 3.10, begins subdivision, subdivision 5.
Senator Westrom.
Sure, I'll pass.
Any further discussion on Senate File 447 as amended? Senator Carlson, as a co-author on the bill, moves that Senate File 447 as amended be recommended to pass and be re-referred to the Senate Committee on Finance. All those in favor say aye. Aye. Opposed?
No.
Motion prevails.
Thank you very much, Mr. Chairman.
Thank you, Senator Rust. Members, we're going to reorganize the agenda here in. Oh, I'm sorry. My chair's agenda is in a different order than the public agenda. So next up is Senate File 1098. As I'm the chief author of that, I will hand the gavel over to our Vice Chair, Senator Umu Verbet. Yeah, yeah. You're our best witness, I think.
Only witness.
Okay, we've got Senate File 1098. Senator Latz, when you're ready.
Madam Chair and members, Senate File 1098 is the Judicial Branch's Policy and Appropriations Bill. It's anticipated that we will hear the bill and lay it over for possible inclusion in the omnibus budget and policy bill that'll be forthcoming from this committee. Since I have the expert on the Judiciary's policy and appropriations issues sitting to my left, I'll simply ask our committee, our Judicial Branch Chief Administrator Jeff Shorba to explain the bill.
Thank you, Mr. Shorba.
Thank you, Madam Chair. Lead Limmer, members of the Judiciary and Public Safety Committee. As Senator Latz said, my name is Jeff Shorba. I'm the State Court Administrator for the Minnesota Judicial Branch. I'm pleased to be back before the committee to present Senate File 1098, our budget and policy bill. Thank you to Chair Latz and Lead Limmer for authoring this bill. We've distributed a handout that contains a summary of both the funding and policy provisions in the bill. On the back page of that handout, you will see a summary of Section 5 of the bill, which contains our biennial budget request that I presented to the committee on January 22nd. As I mentioned in January, we recognize that this session begins with a challenging budget forecast, requiring you to make difficult decisions about how to allocate limited resources. And we remain committed as stewards of public funds to approach this in as careful a manner as possible, being responsible for these funds. Our courts are funded almost entirely through legislative appropriations. All of the revenue we collect through court fines and fees is deposited in the state's general fund or to local government or other statutorily mandated programs. We don't retain any of that revenue. So we really do depend on your appropriation to fund the vital work of our judiciary. As a co-equal branch of government, we have a duty to our employees, judges, and the people of Minnesota to secure funding necessary to fulfill our constitutional obligations. Justice delayed is justice denied. And given the modest share of the state budget allocated to the judiciary, we respectfully urge our partners in the executive and legislative branches to prioritize the essential role of the courts in ensuring timely and effective justice for all Minnesotans. Our overall biennial budget request is $112 million, which is 12.51% increase over the fiscal year 26-27 starting biennial base budget. It includes $77 million in fiscal year 26 and 27 to increase judicial officer salaries by 6% in each year, create an employee compensation increased pool of 6% in both years, fund the employer share of anticipated health care cost increases, and fund the increased cost of leasing office space in the Minnesota Judicial Center. Our request also seeks $5.1 million in 26 and 27, and $1.764 million in 28 and 29 to meet new federal digital accessibility guidelines, $4 million in 26 and 27, and $800,000 in 28 and 29 to improve electronic data sharing with state and justice partners, $7.22 million in fiscal year 26 to increase pay for contract forensic psychological examiners from $136 per hour to $175 per hour, $18.448 million in 26 and 27 to raise the juror per diem rate from $20 a day to $100 a day, and to raise juror mileage reimbursement from 54 cents per mile to 67 cents per mile, which is the current IRS standard mileage rate. $3.5 million in 28 and 29 for permanent funding for the judicial branch cybersecurity program, and $14.790 million in 28 and 29 to address long-term deficits in psychological services, court interpreter, and jury programs. Since I discussed these requests in greater detail in January, I just wanted to briefly remind you what was included in our biennial budget request. In addition to our budget request, we have 3 small policy items to address some statutory updates and improve processes for staff, judges, and court users statewide. These summaries begin on the front page of the handout we provided. Section 1 and 2 address an outdated statute that requires paper filings to be filed at the courthouse where the case is venued in St. Louis County. This bill would allow court filings to be accepted at any St. Louis County courthouse, improving the efficiency and convenience for court users. Section 3 eliminates the 2-page limit on Appendix A notices for child support, spousal maintenance, custody, and parenting time orders. This change would allow us to better comply with updated legal and digital accessibility requirements. Recent legislative changes have required the court to put additional information on these notices and to be compliant with digital accessibility standards. The notice is now 4 pages. Section 4 is a small fix to align the conservator statute with the guardian statute and requires conservators to serve annual reports to individuals under conservatorship, increasing transparency and accountability. Mr. Chair, Madam Chair, and members of the committee, that concludes my remarks on the bill. Thank you for your leadership, dedication, and commitment to the people of Minnesota. I'd be happy to answer any questions you may have.
Thank you. I believe we have one more person signed up to testify. Jake Jadwell. You can come forward.
Good afternoon. My name is Jake Jagfeld, and I'm a member of the Minnesota Association for Justice. I've been a practicing trial attorney for the last 17 years and work as a partner with Johnson Becker, which is a civil litigation firm in St. Paul, Minnesota. I'm coming here today to testify briefly in support of appropriations for increasing jury per diem. I, along with my colleagues in Minnesota Association for Justice, believe that our jury system is the best in the world, and to maintain that and to provide jurors their due for the work and service that they're putting in on these important civil matters should be appropriately compensated. Good examples are primarily arising out of the metro counties, where oftentimes, apart from just taking time away from their own lives and families and jobs to work as jurors, they're having to come into downtown Minneapolis or downtown St. Paul, and just the costs involved with doing that are typically going to be more expensive than a $20 per diem is helping them to offset. And so essentially that's the basis for my testimony here today, and I'm hopeful that if you have any questions, I can answer those. Otherwise, thank you for your time.
Thank you for your testimony. Is there anyone else who wishes to testify on this bill?
Thanks.
Okay. We'll move to committee discussion then. All right, no questions. Senator Latz, final words? Oh, Senator Westrom.
Madam Chair, Senator Latz, and maybe your first testifier, looks like you're adding an annual report for conservators in this bill. Is that correct? And how much extra work is that versus what's the current practice?
Mr. Shorba.
So, Madam Chair, Senator Westrom, we're not adding, we're just requiring it to be served on the person who's under conservatorship so that they'll know what's in that annual report that the conservator has to do. So we're trying to have a little more transparency for it.
So,
Senator Westrom.
Mr. Chair, currently they're doing an annual report. This just stipulates that the person under conservatorship for sure gets that report also, so they are in the loop better, if I'm understanding it correctly.
Mr. Shorba.
Madam Chair, Senator Westrom, you are correct.
Okay.
Okay, Senator
Madam Chair,
Latz.
I have a question for Mr. Shorba. Where does that conservatorship report go now?
Mr. Shorba.
Madam Chair, Senator Latz, it goes to the court.
Only to the court?
Yes. And I have my own experts here if you have more detail you'd like about it.
Nope, that was the
That's
only
about the
question.
limit of my knowledge, but okay. Thank you.
Okay, any final comments, Senator Latz?
Madam Chair, I've appreciated Senator Limmer's co-authorship on this, and over the years, our joint efforts to fully fund the independent branch of government that the judiciary represents, and the importance of it for justice for all Minnesotans, regardless of where they interact with the system. This is a budget proposal that is based upon the judicial branch's request in light of the previous forecast and the needs of the branch. It has not yet been through the filter of our new forecast and whatever the governor is going to release as the governor's updated budget, which I think is expected to come out at the end of this week. So this committee is going to have to do some serious work as we figure out how to handle the upcoming budgetary needs. I know it's the kind of thing that we'll continue to work on a bipartisan basis to, as much as we possibly can, preserve the financial as well as other independence of the judicial branch. Thank you, Madam Chair.
Thank you. And with that, Senate File 1098 is laid over for possible inclusion. And we'll go to Senate File 2039, Senator Latz.
Thanks, Jeff. Hi, how are you? Yeah, good to see you, Judge. Thank you, Senator. Judge, how are you? Madam Chair,
Yep, when you're ready, Senator Latz.
it's not often that I get to present a bill, let alone be flanked by testifiers, Chief Judge of the federal courts here in Minnesota, and still Chief Judge of Ramsey County, former Chief Judge of the Second Judicial District in Minnesota. It's my honor to do so, and it's here. This bill is here because of a very real concern. And although I am flanked by substantial and accomplished people, I'm not flanked by security experts, nor am I flanked by people who have necessarily been trained for the purpose of providing for my safety or the safety of anyone else. But that's the risk that they face every day, and all of their colleagues on the bench and within the judicial administration, certainly within the judge's offices, their clerks, their staff, and so on. It has become more and more dangerous a job to perform, not only as they make difficult decisions in which people are winning and losing money, access to family members, freedom, but also as our societies become more polarized and the public environment has more and more frequently attacked judges on an individual basis as well as collectively for the decisions that they make. And it is not a very friendly or helpful environment. And whatever one's position is on the merits of decisions or on the appropriateness of questioning decisions on their merits, it certainly has increased the physical safety risk to the judges, their families, and their staff. This is a bill that, a proposal that we heard in 2024. We passed it without we passed a safety bill without one important component. And the important component was incomplete in terms of how it would be implemented and could be implemented effectively in Minnesota. And that has to do with the individual property addresses of the protected parties. We have brought that back now before this committee. After the stakeholders have worked since last legislative session, all of those who are involved in implementing, as well as would be involved in being protected by these initiatives. What we have before us now is a result of that stakeholder work. I understand there may not be 100% agreement on all the provisions yet, but we are very, very close enough, and given the timeline in this legislative session, at the point where the decisions now are going to have to be placed in the laps of this committee, and so that it can move forward. I think it is really, really important that we do so. So with that setup, Madam Chair, I'd ask you to hear from our testifiers, and then we can have a conversation as a committee.
Thank you. So one of your testifiers want to go first?
Yeah, I'll go. Hello, thank you, Mr. Chair, Madam Vice Chair. I'm John Guthman. I'm a senior district court judge from Ramsey County, appointed to the bench in 2008. I'm here in two capacities this afternoon. First, I'm a member of the Minnesota District Judges Association, whose membership consists of most of the district court judges in Minnesota, along with Court of Appeals and Supreme Court judges, and many retired district court judges. I'm also a member of the Legislative Advisory Work Group, which advises the Minnesota Judicial Council on matters of public concern and public policy to make up the judicial branch's legislative agenda each year. Both the MDJA and Judicial Council have made judicial safety a continuing commitment through passage this year of the real property amendments to the Judicial Court and Staff Safety and Privacy Act, which passed last year thanks to your support. Again, thanks to action taken by the legislature last year, the statute was enacted. It allows judicial officials to have their personal information classified as private, prohibit its dissemination, remove their personal information from the internet, and prescribe criminal penalties for publishing a judge's personal information with the intent to threaten, intimidate, harass, or physically injure. Enactment of the statute reflected the legislature's support for preserving the rule of law and an independent judiciary in a climate in which threats of violence are often directed at judges, judicial staff, and the family of judges, including children. And since I testified before you last August, I had yet another fist fight in my courtroom where people were scurrying for their own safety and people were getting arrested in the courtroom. If they're doing this in the courtroom where we have to scurry for our safety, you can imagine what people who wish violence on judges and judicial staff are going to do in their spare time when they're not being watched by a room full of deputies. Last year, we shared data with you indicating that judges ranked #1 for targeted attacks against government officials in the United States. Today, if anything, the climate in our society is worse. Hardly a day goes by without hearing of threats against judges who are simply doing their jobs. Although passage of the statute last year was crucial, as Senator Latz just indicated, there was a large loophole left. It was left by necessity, due to the complexity of dealing with real estate property matters, because we wanted to make sure that our efforts to protect judicial officials don't interfere with the smooth operation of our real property system, because we all want to be able to buy and sell our houses and everything that goes with that. So we need to close that loophole. We promised last year that we would work hard to do that. We have completed our work, and I think we have succeeded. You've each been provided with a summary of the working group that we had. It was a very diverse group from all aspects of the real estate system and those who support it. We had 15 meetings of large and small groups. We consulted between meetings. The initial draft of the legislation before you was prepared not by judges, but by real property professionals. We also met with other stakeholders who weren't in the large group, and folks like Min Koji, the Minnesota Newspaper Association, Rich Neumeister, and the Civil Liberties Union. I also want to thank co-authors Senator Limmer and Senator Latz for their support of this process. We had a number of complex issues to work through, such as treatment of those large and dusty tract books that make you sneeze when you're looking for information. How are real property records kept and accessed and indexed during the digital age? Ensuring that real estate professionals and lawyers can do their work and do their job while preserving the confidentiality of personal information to the greatest extent possible. Through compromise, much of the onus is placed on the judicial officials seeking protection in order to minimize the involvement of government employees. Judicial officials, under the legislation and proposed amendments today, have to request protection in a form that they fill out, and they are required to specifically identify by parcel number the information they want to protect. So county recorders are not going to have to spend time randomly searching through records to find things regarding certain people. The law will require that they be told exactly what to look for. Only digital and internet-based records are protected based on a compromise we reached just this last Friday. Paper tract books and electronic copies of tract books were excluded at the request of county recorders, after we discussed the fact that without other digital records, no one will be able to associate a property with a name. So after months of hard work and collaboration in meetings and between meetings, I believe we have come as close to a consensus document as one can reasonably expect without making the statute meaningless. So I urge you to vote yes for judicial safety and continue your commitment to preserve our independent judiciary and encourage more people to apply for judgeships. The applications have plummeted, and safety is cited as one of the top reasons why people are not applying. Thank you for your consideration, and I'm happy to answer any questions you might have.
We'll move to the next testifier. If you want to just begin by stating your name for the record.
Yes, my name is Patrick Schultz. I'm the Chief Judge of the Federal Court here in Minnesota. And I appreciate the opportunity to speak to you today. As Senator Latz referred to, the number of threats against federal judges has increased dramatically in the last few years. And many of those who are making these threats have been using the personal information of judges and their family members that is easily accessible online. That is why we judges are grateful for the judicial security legislation that you passed last year. It was a critical first step toward protecting the safety and security of those of us Minnesotans who serve the judicial branch. Unfortunately, though, the bill that was passed last year had a huge loophole. It failed to protect the property records of judges, even though property records are the most common reason why our home addresses are found online. When we are at the courthouse, we are safe. In the federal courthouses, for example, we have armed court security officers who screen everybody who enters the courthouse. At home, though, we are vulnerable. It is no coincidence that every attack that has occurred against a federal judge or a family member of a federal judge has occurred at the judge's home. And just consider a few examples of recent attacks on judges. In 2023, Washington County, Maryland Circuit Judge Andrew Wilkinson was killed at his home by a disgruntled litigant. Investigators later discovered that the killer had searched the internet for information about Judge Wilkinson, whose home address was readily available online. In 2022, retired Juneau County, Wisconsin Circuit Court Judge John Romer was zip-tied to a chair, tortured, and killed in his home by a man whom the judge had sentenced to prison some years earlier. In 2020, the 20-year-old son of my friend, federal judge Esther Salas, who lives in New Jersey, was killed, and her husband was critically wounded at their home by a disgruntled attorney who was trying to kill Judge Salas and who had found her home address on the internet. In 2005, a disgruntled litigant went to the home of federal Judge Joan Lefkow, who is in Illinois. He intended to kill her. She happened not to be home, so he killed her husband and her mother instead. In 1989, Circuit Judge Robert Vance, who lived in Alabama, was killed at his home by a disgruntled litigant who mailed a mail bomb to his home. In 1988, Judge Richard Duranko from New York was killed at his home while tending his garden by the father of a disgruntled litigant. And finally, in 1979, Judge John Wood of Texas was killed outside his home by a contract killer. I should note that in the almost 200 years that our country existed before Judge Wood was assassinated, a total of one federal judge had been killed. One, in a duel with a political rival in New Mexico territory in 1867. So one up to 1979 and the ones I've mentioned since then. Putting aside the duel, the common thread that runs through every single attack on a federal judge or a member of a federal judge's family in the history of our country has been the attack occurred at the judge's home. The law that you passed last year to protect the information of judges was well-intended and it was appreciated, but omitting property records from the law's protection created a loophole so large that it essentially defeats the purpose of the act. If we judges could protect only one category of our personal information, only one, it would be our home addresses. And that's the one piece of information the law passed last year does not protect. I urge you to approve the amendment that's pending before you to close this loophole and to protect the property records of judges and their family members. As noted, this amendment represents the work of many stakeholders, including state judges, and the Federal Bar Association, who came together to propose a way to close this loophole without unduly burdening and disrupting the important work of the other parts of government. We very much appreciate your work so far to protect us, and we very much appreciate your interest in trying to improve that protection, in particular extending that protection to our home addresses. Thank you for giving me the chance to testify today.
Thank you for your testimony. Senator Latz, do you want to move forward with the amendment?
Madam Chair, I move adoption of the A1 amendment as an author's amendment. It reflects the compromise of the stakeholders.
All right, Senator Latz moves the A1 amendment. All those in favor, say aye. Aye. Okay, the amendment's adopted. And then we do have some testimony from the Minnesota Association of County Recorders. If you want to come forward. And whoever wants to go first, just speak in by stating your name for the record.
Thank you. Good afternoon, Madam Chair and committee members. I'm Amber Bouget, and I'm the Recorder and Registrar of Titles for Hennepin County. I'm also the co-chair of the Minnesota Association of County Recorders, which is part of the Minnesota Association of County Officers, which also includes auditors, treasurers, and financial officers. I thank you for the opportunity to testify this afternoon, and thank you to the members of the Judicial Safety Working Group for their collaboration in addressing concerns we've raised. While this legislation and the amendment represents significant progress, we remain deeply concerned about several critical aspects of this bill. For county officers and other government entities to effectively comply with the retroactive privatization of personal information of judicial officials, it is essential to narrow the scope of this law. Specifically, we're recommending limitation of the application to real property records that are made publicly accessible via the internet. This approach is particularly relevant for tax, assessment, and other real property records. Identifying and redacting personal information is exceedingly complex due to the diverse digital formats in which these records are stored. For instance, many records exist as scanned PDFs, microfilm, or other file and media types. They require significant effort and resources to redact accurately. Also, historic records often contain a list of all individuals, not a separate document for each parcel in tax records and other real property records. Those records aren't indexed or stored by parcel either. This means staff hours to flip through records and redact sections of certain pages. Another significant concern is the classification of judicial officials' personal information as private data under Chapter 13. This classification would subject government entities to extensive legal remedies, which were not originally intended for real property records. Unlike other Chapter 13 records, many real property records have already been widely disseminated, and they play a vital role in supporting commerce, protecting property rights, and ensuring transparency. Further, this personal information can often be obtained through means other than the real property records. For these reasons, the Minnesota Association of County Officers cannot support this bill without a limitation on liability. To address this issue, we propose a $5,000 civil penalty cap. We appreciate the committee's time and consideration of these concerns. Thank you for the opportunity to testify today.
Thank you. And I believe we have Andrew McGuire.
Yes. Good afternoon, Madam Chair, committee members. My name is Andrew McGuire. I'm the Property Records Manager at Dakota County, but I'm speaking as a representative of the Minnesota County Recorders Association and the Minnesota Association of County Officers. Dakota County has no official stance on the legislation. Thank you for taking the time to hear testimony on this matter. I appreciate the opportunity to collaborate and craft legislation that would both serve the community need while allowing counties to provide efficient and effective service. I would like to share with you one of the unforeseen consequences of this bill that may give us some pause. The scope of this legislation is expanding exponentially. What began as protections for judges numbering about 300 was expanded to cover about 2,500 judicial staff. Since the beginning of the session, county attorneys and peace officers have also worked to expand the definitions to cover themselves, and there are over 10,000 peace officers in Minnesota. This is consistent with what we have seen in every other state that has introduced similar language. The number of protector groups will expand. For each of Minnesota's 87 counties, there will be unique challenges in implementing and administering this legislation. As housekeeping bills are passed or other groups become covered, these challenges will only grow. Uniformity in process and efficacy will undoubtedly suffer as our ability to vet the applicants, mask their records, and then facilitate access to their privatized data will be strained. And for some of our smaller counties, the strain will be amplified as there are fewer people employed that can perform these types of tasks. We would ask that the authors consider that an administrative authority would be able to efficiently handle enhancements in communication with protected persons and other government agencies. As Safe at Home is overseen by the Office of the Secretary of State, so too will this program need oversight. Thank you for the opportunity. I look forward to continuing to collaborate on legislation that will allow local governments to efficiently fulfill the needs of those needing protections.
Thank you. Just before you leave, Mr. McGuire, I did have a question, and I think you beat me to. I was wondering how many people and records this potentially would be, and you said your understanding was it was going from about 300 judges to roughly 2,500, including all the judicial staff. Did I get that correct?
Correct. And then the peace officers are on board as well and working to alter the definitions, so it's growing.
All right. Did anyone else wish to testify? Okay, Rich Newmeister, you can come forward. And just begin by stating your name and for the record.
Thank you. Madam Chair, for the record, my name is Rich Newmeister. I feel lonely like I was 34 years ago when I testified against the first attempt to register sex offenders, because at that time, it was not considered constitutional yet. And I feel like that way a little bit here against, a bill is trying to prevent bad things from happening. But I want to highlight some things very specifically, Madam Chair, which the author already knows about by a letter, and so does Senator Limmer, because I sent them a letter. I did not have enough time because I just came into town after the deadline to submit written proposals. I think this bill is unnecessary and weakens transparency and sunshine in our judicial system. Now, Judge Guthman knows me well, and so do the supporters of this bill. I was not too much involved on what was passed last year, but this year I was. I was involved in a meeting, and I thank Judge Guthman and Nancy Hawes and those folks for being part of that. But it was very clear in my discussion over the last 2 years and with Judge Guthman, this is limited protection. This does not really solve the issue that you are all trying to do, and it's excessive. As I said to people, privately. I have gotten judges' addresses just by going on the internet. I'm not going to say who, but if you want to know, I can tell you, but it's easy. Or you pay $10 to be able to do that. So this creates barriers to access to look at conflicts of interest of the judicial, particularly the judges. In property cases, they do zoning cases. And address is important to be able to make sure it is that right judge, because many times in the property that they own, they must list their personal address, other than the home that they may own. As it seems, as we know, the old word inertia or movement or whatever, the momentum is there for this bill to pass. But if you're going to pass it, I'd like to point out some inconsistencies based on what you did last year and what's happening this year, and I think it's important to address. So if you look at Section 4, page 5 on the bill, you'll see the new legislation classifies data as private. But if you look on page 5, same, and line 15, you'll see where a section starts to go in, and it says that the classification does not take effect until the notice is given by that individual judicial official, which I have seen at least figures of at least 3,000 people. So that's one consistency. Because if you look at the current law on review, page 1, line 9 through page 2, and line 2, this is what I referred to where there's the inconsistencies. Because the classification of the personal information held by all other government entities other than property, real property records, and whatever document might be, it's automatic, just like we have generally classified data. And the only notice that is given, as the law says, current law says, is for the remedies. So let's say, for example, judges or judicial officials' data goes out. Well, it can only use the remedy if they do the notice. Another difference. If you look on page 7, line 21, when the judicial official is no longer employed, they must file a notice to the county recorder where the data, which was private, will become public. And you'll see the configuration about that.
I'm sorry, Madam Chair, I'm sorry to interrupt. Mr. Newmeister,
Senator Latz.
I'm looking perhaps at a different draft than Mr. Newmeister is referring to. So perhaps he can identify if he's looking at the as introduced, because,
Which part?
well, the last reference, and I wasn't sure even about the previous reference. I have the as introduced version in front of me.
Okay.
I just want to make sure I get the references accurate.
Yeah, absolutely. And we did adopt the A1 amendment.
On page 7, line 21, you'll see that the notice must be sent, no longer qualifies as a judicial officer. So that means real property records that are made private by the first notice, which is on the line that I indicated to you, page 5, line 15.
Thank you.
Because the notification, that's where the classification becomes active. And the classification is on page 5, line 2. So what you have here is classification, the notice that makes the classification effective rather than the traditional way of classifying private or confidential data. And then further on, you have the language that says that on page 7, where once the judicial officer no longer qualifies as a judicial official, they must send notice to the county recorder so that the data becomes public. It's not private forever. And that's with the current law, data that you made private last year in 13.991 on pages 110 through 113, it's private immediately. So it is classified. So one of the things that I noticed the difference is is that on one side, with the new version, data becomes public after a judicial official, if they do the notice, within 90 days, I believe, the county recorder will then make it public. The other thing, though, it does not happen with all the other government data that you made private last year. It's kept permanently. And there's like a 10 to 15% turnover in the judicial system of employees. I've seen those figures. And so then that data becomes private permanently. I'm just trying to share with you at least differences that I see. While protecting the safety of judicial officials is a valid goal, the legislative schemes to address this are excessive. I think a narrow approach could have been done. In summary, the bill risks hiding conflicts of interest, inspiring darkness in government, stifling oversight, and overreaching on privacy at the expense of transparency and sunshine. Madam Chair, I've shared with the two lead authors who have contributed to this bill the last 2 years specific comments, and I'm more than willing to talk with them afterwards as the bill progresses or whatever. Thank you, Madam Chair and members of the committee.
Thank you,
Have a
Mr.
good day.
Newmeister. Okay, we'll go to committee discussion unless you had some comments,
Just to
Senator
let
Latz.
the chair know, Judge Guthman has indicated to me he's available to respond if committee members have questions to Mr. Newmeister's references.
Great. Senator Kroon.
Thank you, Madam Chair. We heard from the county recorders, and I noticed that the Association of Minnesota Counties also submitted a letter. And I'm just trying to figure out like how much, I mean, we heard a lot from the county recorders about the immense amount of work, and the county, and the Association of Minnesota Counties talks about considerable staffing responsibilities, and also about the liability standards. I guess my question is, do we, and maybe this is for the bill author, maybe the Association of Minnesota Counties, if they're out there, if they could come and testify, do we know how, do we have an estimate of how much this is going to cost counties in additional work, or what the price tag will be for them?
If you have an idea, Senator Latz, otherwise, I know we have the representatives from the Minnesota Association of County Recorders here. If you'd like to speak to that, you can come forward.
Come on forward. Madam Chair, I don't have any specific numbers. I'm not sure if there's been a fiscal note formally requested, and if it included a local fiscal impact component or not.
Ms. Bouget.
Yes, I can only speak on behalf of Hennepin County and what we've done for previous programs like this. For Safe at Home and for the federal Daniels Law, it takes a good 10 to 15 hours of work of generally a supervisor or manager level because of the sensitivity of the data to work through one of these files and to provide access to our title professional partners and other administrative tasks that must be done for these requests. So that is just an estimate. I know other counties who have not had any Safe at Home requests or any Daniels Law properties will be challenged with this because they don't have a process yet. Also, their staff are limited, and so I can't say what the actual costs will be. There could be technology costs as well. Thank you.
Thank you. Senator Kroon.
Thank you, Madam Chair. Yeah, and I don't know if there's been a local impact note requested or not. I'm just wondering if, it sounds like it's going to be pretty costly for the counties. And I'm just thinking if there's a way to, it's obviously a noble cause, and I support the sentiment of the bill, but I'm just wondering if there are ways to reduce the costs. And I think you mentioned a couple from the county recorder's perspective. I mean, the first one that comes to my mind is when you go from just judges and immediate family to all judicial staff. To me, that's where it just becomes really a huge endeavor, and I don't know if that's a possible way. If the bill were to be limited to just judges and immediate family members, would that make a significant impact on cost from your perspective? And also if the Association of Minnesota Counties has a better grasp on a statewide cost, I'd certainly be interested in hearing from them.
Madam Chair.
Yes, Ms. Bouger.
Oh, sorry. Madam Chair, Senator Cruen. So for that limitation to just the judges and their families would definitely reduce the costs and the stress on county governments for this, as well as other government entities who hold real property records. I believe that number is about 300 for the judges. So compared to 2,500 plus families of those 2,500, it would definitely lessen those costs.
Okay. Senator Cruen, I'll go to you in a second. I just wanted to mention that we do have Nathan Zacharias here with us as well from the Association of Minnesota Counties, if you wanted to come forward and maybe speak to the question before you proceed.
Thank you, Madam Chair. Nathan Zacharias, I'm the Technology Policy Analyst for the Association of Minnesota Counties. I don't want to go over all of the technical aspects. I think the recorders have covered that adequately. I just wanted to say that philosophically, we are definitely not opposed to this bill. We want everybody to feel safe in their homes, and they have the right to do so and should. But we are concerned about the precedent setting, and we've heard a little bit about that. There are a lot of county employees with public-facing jobs. I'm thinking of jailers, correctional employees, child protection workers, in addition to the others that have been mentioned today regarding peace officers and so on. As that list grows, AMC is particularly concerned about our smaller rural counties, who often have very few employees and do struggle quite a bit with workforce retention and recruitment for public jobs. And so I just wanted to offer that as a piece of information for the committee to consider. And we have very much enjoyed working in the stakeholder process and want to continue to do so and feel like all of this work has been done in earnest with the Judges Association.
Senator Cruen.
Thank you, Madam Chair, and I'll just make this final comment so other committee members can get involved. But I used to be a law clerk many, many years ago now. I understand the intent of this and I'm sympathetic to it. It just seems like it maybe is more broad than, I don't want to say needs to be, but just considering the cost, which we don't seem to know what that total cost is, it doesn't seem like anybody has a firm grasp on what that's going to be. And I also, we have a public real estate land title records in this state, but if we, I'm hearing that there's bills out there for law enforcement officers and even county attorneys, and then potential other bills out there with corrections officers, jailers, child protection. I mean, at some point, this is going to get to be too big. The costs are going to be too high. And I'm not saying we should do nothing because of that, but it seems like if we have to be very mindful of what we do with this bill is going to be modeled with those other groups. And we have to think forward about what the implications are when these other groups who have legitimate claims to privacy and safety as well, what that's going to do to our system and the costs associated with that. So, I'm in favor of the bill. I'm sympathetic to the sentiment and what it's trying to do. I'm just wondering if we as a committee can maybe look for ways to narrow it, and whether that's the types of documents that the county recorders have to search and put the time in, or whether it is making it just applicable to judges and immediate family members. That might be something that would be worthy of consideration. Thank you.
Thank you. I was also wondering if maybe there's a way to kind of scale, starting with judges, moving into staff. I know Ms. Bouger talked about the certain counties having a process and other ones needing to develop that. If there's a way to kind of pilot to get a good system in place, and then once you've got a process, then being able to go through more records. But there has been a fiscal note requested, and I think a revenue note as well. So hopefully we'll have more information for the committee soon. Senator Westrom?
Thank you, Madam Chair. First of all, Mr. Zacharias from the counties, do you have a rough estimate of costs that you guys have brought up or put together for counties just dealing with this? And then I have a question for the recorder, Madam Chair.
Mr. Zacharias?
Thank you, Madam Chair and Senator Westrom. I do not know that right now. I can check, but I'm not aware of any such estimation at this time, but perhaps the recorders might have a better idea.
Senator Westrom?
Madam Chair, to the recorders, can you walk us through the process a little bit more in how do you scrub this from the records, and how would this get scrubbed from the public records that are already out there? Is there a way to do that, or is it something we just have to do going forward if we were to do this? And then I have a follow-up.
And Ms. Bouget, if I could just add to that, if you can clarify when answering the question, what that looks like for the records that are available through the internet, because you differentiated those in your letter, and then other records. Please proceed.
Madam Chair, Senator Westrom, so each county is different, and right now, there is the Safe at Home process, which is moving forward. So that means that a Safe at Home participant must move from their home in order to get these protections. And in this case, that is not what the request is. It is more akin to the federal Daniels Law, which is a very vague law, but we have implemented that fairly successfully with the help of the federal judicial clerk and deputy. And that having that oversight of either the Secretary of State's office or the judicial clerk has been extremely helpful in implementing and answering questions that might come up. Now, particularities in how this works for Daniels Law, because that is similar to this in that it is retroactive records, we would need to go back into our historical records. I do want to say this, that the law is very tailored to helping the county recorder with this by having the judicial official identify the document number and the certificate of title number. However, this does not just apply to county recorder records. It applies to any government entity who holds real property records. And so that includes auditors, treasurers, cities, public works offices, and others. So that is where it gets a little more tricky in identifying exactly what records to make private. That is why we've asked to have this limited to only those records that are made publicly available over the internet. And that would help. It wouldn't alleviate all the work that goes into this, but it would at least limit it to those records and the digitized records that are held at county government entity offices with information on real property records would still remain intact.
Senator Westrom.
Madam Chair, thank you. To your last point, would this be protected even with somebody coming into the county office and asking for records? Because the delineation you're referring to, the digital records, I practiced in an age where you don't just pull everything up online. You'd either call the county office or you'd go there to get your records. Would that be treated different as well? Or how do you do that now?
Ms. Bouger.
Thank you, Madam Chair, Senator Westrom. So under Daniel's Law and Safe at Home, it applies to all of the records. So Safe at Home, again, easier because we're managing that from the start of the information that comes to our offices. So that is much easier to do. Going backwards for Daniel's Law, we would not make that public on the internet. We would not make that public via someone coming into our office. However, in this instance, if we were to limit it to those records that are made publicly available, someone coming into our office, yes, could request this information. And I do want to say that, again, for the property tax area, for other records, it has been challenging with getting the information scrubbed from those records for Daniel's Law federal judges and their families.
Madam Chair,
Senator Latz.
I think Judge Guthman has some updated information from the compromise that was reached last Friday that's relevant to these particular questions.
Judge Guthman.
Thank you very much, Madam Vice Chair, Mr. Chair. A couple of items. First of all, for non-real property records, I can attest personally how effective this law has been with relatively little effort by employees of the government. One of the things that prompted my interest in this subject was the inability to get my certificate of election removed from the internet by the Secretary of State. It had my address on it and was sitting on the internet from 2008 until last summer, when the law went into effect on August 1st. I emailed the Secretary of State's office. Technically, I'm supposed to complete the form and file the form. They voluntarily took that document off the internet with 2 emails, and it took less than an hour. And that includes how long it took me to find out that they had done it. So if the document and the information is readily identified by the judicial official, it takes very little time and very little effort. And that assumes the person actually did it. At the request of Ms. Bougie and others in the county recorders and the Minnesota Bar Association real estate section, we have limited the scope of this law to online and digital records. So certainly if someone comes into the office, we want to protect the records, or else it doesn't really do any good to do anything at all. We specifically, at their request, exempted physical tract books and copies of tract books based upon the representation that you wouldn't be able to even know where to look in those sources without the other digital information that would be protected. And to these records and other government records such as auditors, et cetera. Again, unless the form is submitted by the judicial official, protection doesn't attach. So this isn't a matter of, oh, we have to protect Judge Joe Blow or their law clerk's information and we got to go find it. The judicial official has to tell them where to find it and what it is, or it isn't protected. This was done at the request of the county recorders and government officials to minimize the amount of time that it would take to find the information if a request is made. And we haven't heard any anecdotal information from any sources that a significant number of requests have been made based on the law that passed a year ago, which did include and does include employees. My law clerks in the past have been threatened with death on the telephone. We have court clerks who get threatened and are easier targets if they know they can't get at the judge. So you have acted wisely in the law to date, and we urge you to continue doing that in connection with this amendment, so it will be effective.
And Judge Guthman, just to clarify, you spoke to judges needing to make the request, but that would apply to staff as well, so.
That's because the definition of judicial official includes staff, so the written request would have to be made by staff as well. And Mr. Neumeister is correct. It's unlike non-real property records, there isn't automatic protection. You have to ask for it. And one of the reasons for that difference is to make the scope of the real property amendments narrower, not broader, to put the onus on the judicial official to address exactly the concerns that have been raised. So I believe we've responded reasonably, and any further dilution would make the law ineffective.
Senator Westrom?
Madam Chair, thank you, Judge Goffman. To those points, if somebody's legitimately trying to get a hold of you for a credit reason or some other non-nefarious reason, how would they get a hold of you or a judicial official, maybe to make it, not make it personal? Just what would be the processes for, there's a legal notice or other notices that need to be given out? Do you take an alias name and the county officials know what that name is, or?
There's two mechanisms.
What's the process?
There's two
Gutman.
mechanisms in the law. The first mechanism is that person can make a request from the county for that particular information. They know the person's name. And there's an exception, it's in the amendment you just approved today, which we added just last Friday, that allows attorneys and other professionals in the field the right to get the information and use it as reasonably necessary to do their jobs. So they have a special point of access, and they can continue using that information. For example, in a contested quiet title action, you have to publish the information, and the law as proposed would allow that to happen.
Okay.
Senator Westrom?
And Madam Chair, Judge Goffman, what about like public utility bills or other things like that? I'm assuming it's probably handled when you sign up for your services. And does that play over into the internet at all, or is that already protected customer data between the utility, the city utility, and the customer, if you know?
Judge Guthman?
Yeah, thank you. Senator Westrom, this legislation doesn't impact any other data privacy laws that exist.
Okay.
So to the extent any customer of the utility has some protection of their personal information, that same protection applies. But if the judicial official wants a government agency to have further level of protection, it has to be requested in order for there to be a remedy.
Okay. And Madam Chair,
Senator
last
Westrom?
question. To the recorders, you talked about your suggestion of a civil penalty of, I think, $5,000. Can you explain that a little more or expand on that? Are you saying you suggest there's no criminal penalty to this, but it's enforced through an aggrieved party bringing a civil action or a civil penalty could be imposed if a violation? Expand on that a little, if you could, please.
Ms. Bourget?
Thank you, Madam Chair, Senator Westrom. Yes, because this information has been out to the public for however long someone has lived in their property, that information could have been gained by someone with nefarious intent in other means than from our records. And, the hope is that we would definitely do everything we can to comply with this law. But given that that information is already out there and is very different than other other government entity information, because real property records have been made public since the beginning of the state. So that is why limiting the liability is very important to protect taxpayer money from being spent on challenging someone coming forward with an action.
Senator Westrom?
That concludes it for now, Madam Chair, but I might have a question. I'll let others ask first.
Okay, thank you. And Senator Latz.
Madam Chair, Judge Guthman can update us on the penalty provisions as well.
Judge Guthman.
Private data on individuals is protected, and if there's a violation of the treatment of private data on individuals, the current Data Practices Act provides for a civil lawsuit and collection of damages with a cap on liability if there's an intentional violation. So I don't see any rational basis to treat private data on individuals differently depending on who the government official is whose data is being violated. And there's a liability cap for intentional violations already in law, and you would have to prove that the information in the hands of the nefarious person was not legally released. So if they had it 10 years ago, then there wouldn't be any basis for liability.
Ms. Bougere.
Yes, Madam Chair, I'd like to say a few points based on what Judge Guthman has put forward. With respect to that information, I understand that there is a limit in Chapter 13 and that proof would have to be made. However, counties would have to use county resources, the county attorney's office, to represent themselves with respect to any suit that was brought forward. So that is one of the reasons why limitation on liability is important. I'd also like to go back to the point of the digitized information that auditors and treasurers and other government entities hold. That information can be very challenging to redact. And I do not have an estimate of the hours. Each county is very different. Like I said, there may be microfilm of this that's available to the public. There may be PDFs that are reviewed and that would be available to get by a data request by the public. So I think that, again, limiting it to those records made publicly available on the internet is appropriate. And I would like to point back to Judge Schultz's testimony. It seemed like all of the instances were from information that was available on the internet. That is what I heard. I'm not sure if that is accurate or not, and then I'd like to go into the staff. There are other remedies for staff members. The Safe at Home program would be available and is available to anyone who has a threat made against them and would like to apply for that program to get protection. And that program has been around for, with respect to real property records, for over 10 years. And it, to me, has been the best method to keep someone safe from harm. I understand that people do not want to move from their homes. However, in certain instances, that might be what's needed to get full protection. Thank you.
Okay. Senator Anderson?
Thank you, Madam Chair. Looking at both the letters from the Association of Minnesota Counties and from the county recorders, I see that in the bill it talks about service fees to the recorder or the government entity, and they are basically saying that allowing $40 to be used to meet the charge of these service fees is woefully low. And I'm wondering if would there be a number or amount of money that could be added to the bill that could help meet these requirements? Because I keep hearing people say that the counties are short of people, and this would, again, put a bigger emphasis on the recorder's office and other county agencies. So I'm just wondering if there's a thought of what amount of money would be necessary, and if there could be opportunity to add to the bill.
Senator Anderson, I will say, I know there's been a number of questions about that. There's the fiscal note and the revenue estimate coming. I think that Mr. Zacharias also spoke to wanting to get some of that information and provide that back to the committee. But I don't know that they have that available right at this moment.
Well, Madam Chair, I'd like to have some response from the counties or the recorders on that.
Sure, Ms. Bouger.
Thank you, Madam Chair. Senator Anderson, we do not have an estimate because each county is different. The $40 we discussed in the working group, and that is what was we came up with. However, it's become clear that that's likely not enough to cover the costs associated with this. So we would like to lean on the information that will be gathered in the fiscal note and go from there. So I mean, like I testified in Hennepin County, it's at least 10 to 15 hours per individual, and that is supervisor time. So, you know, I could estimate, but I don't believe that's appropriate at this time. Thank you.
Thank you.
Right, this bill is being laid over. I know there will be further discussion. Did you have any final comments, Senator Latz?
No.
Okay. All right, well then, with that, Senate File 2039 is laid over for possible inclusion.
Thank you.
Well, we do have a few more bills on the agenda. I'm just kind of looking to the members to see if folks want to stay to try to get through a few more of those, or if folks need to head to other meetings.
We'll move on to another agenda.
Okay. It looks like we've got people who've got to head out, so we're going to move to another agenda. We are meeting again on Wednesday, and we do have committee planned this Friday as well. So with that,
Madam
committee's
Chair?
adjourned. Oh, sorry.
Just before we
Senator
close,
Latz.
I want to note, with regard to the conversation earlier about the data practices addition to the Attorney General's provision, I'm not unsympathetic to the goals of making sure there's plenty of accountability and public information about how such a restitution fund would be administered. And so I encourage Senator Crewin, as he's working through his own Senate file, to try to reach a broader resolution on that can apply, or at least include this, but I think it needs to go through that process. Thank you.
Madam Chair.
Senator Anderson.
Madam Chair, moving to Friday, I just found out today that the Senate Ag Committee is also meeting at the same time that we're meeting. So it's going to be a little bit difficult for me to be here on a regular basis for that meeting, just to let people know.
Thank you. We'll do our best to coordinate, and we've got the Wednesday hearing as well. With that, committee's adjourned.